Hello everyone, this is Crypto BitLaw back with today's blockchain law policy and regulation update. Today is Friday, February 4th, 2022, and the major happenings today are that Congress proposes a bill to provide tax relief for small crypto transactions. A DAO trying to free Julian Assange has raised over $4 million and counting. Federal Reserve and MIT publish open source central bank digital currency software, and the plaintiffs in the crypto staking lawsuit filed notice of the rejection of the IRS's settlement proposal. So as always, if you enjoy this content, please like this video and subscribe to our channel. We'd really appreciate that. You can also follow us on Twitter. Our Twitter handle is @CryptoBitLaw. And if you want to jump around to any of these particular stories, you can find that in the timeline section listed below. So with that said, let's dive right on in. So first up, we can see that CoinDesk reports that U.S. lawmakers reintroduced a bill to provide tax relief for small crypto transactions. The legislation by a bipartisan group of House representatives would exempt realized crypto gains under $200. They say the Virtual Currency Tax Fairness Act, an amendment to the Internal Revenue Service's tax code, was announced on Thursday. It would simplify tax burdens on daily crypto users who must now report even the smallest capital gains. The lawmakers last introduced this legislation as the Virtual Currency Tax Fairness Act of 2020 in January of 2021. Consumers must now report changes in a cryptocurrency's value in dollars from when they purchased the crypto to when it was used in a transaction, including even minor retail purchases. If it becomes law, the legislation would retroactively apply to all qualifying transactions from December 31st of 2021. Jerry Brito, the executive director of the crypto think tank Coin Center, which has lobbied for the bill, said the legislation would relieve users from having to keep track of small personal transactions. Not only will this create a level playing field for digital currencies, it will also help unleash innovation on applications like micropayments, which can consist of dozens of transactions per minute and thus are difficult to square with the current law. So, I mean, this right here, this just makes total and complete sense. As the law is set out right now, every transaction in cryptocurrency is a taxable event. If you go from Tether to Bitcoin and back to Tether, or Tether to Doge, back to USDC or anything like that, you are taxed on each one of those transactions, and you are supposed to note the time that the transaction occurred and the dollar value of the amount of the crypto at that time, and then account for the gain at the time the transaction occurred, and then you would be taxed according to that gain. That would be the capital gain on this. And so this right here would exempt smaller transactions, under that $200 threshold, and pretty much exempt that from having to be reported in that capital gains tax schema. So in effect, it would permit and further facilitate the use of cryptos for these, as they put it, microtransactions, everyday transactions. So I think that this is very bullish. I think that this could only help fuel adoption, and I have hope and faith that the Congress will actually do something, good for a change and pass this common sense legislation. Next up, we could see that the Block reports that a DAO trying to free Julian Assange has raised $4 million and counting. They say, following in the footsteps of the Constitution DAO, a DAO is raising funds to try to help free Julian Assange. So far, the DAO has raised $4 million, but the funds keep flowing in. So for those that don't know, a DAO is an acronym for what's known as a decentralized autonomous organization, and it pretty much operates like a decentralized form of governance. If you will, it's a decentralized way to it almost acts like a decentralized corporation in a sense, where all of the members of the DAO have a say in how the DAO is being run and what the DAO does and how it acts based on the terms and the conditions set forth in the governance structure of the DAO. But moving on, they say that the DAO, this particular DAO, the Julian Assange one, is currently raising funds to bid on an NFT by digital artist Pack that was created in collaboration with Assange himself. Similar to the Constitution DAO, anyone can donate to the pot of funds, and the contributors receive a proportionate amount of its governance token, known as Justice, in response. And it's certainly catching hold. So far, the Assange DAO has raised 1,441 Ether, worth approximately $4 million. The Assange DAO was formed on Thursday by 10 core contributors. So, wow, I mean, this is pretty quick. They raised all this money. It continues that if the Assange DAO wins the bid for the NFT will be held by the DAO, and its contributors will be given the DAO's governance token justice in proportion to their ETH contributions. Contributors will then decide via governance voting what to do with the NFT and the future roadmap of the DAO. McKenna said there was no initial target for the raise. If the DAO loses the bid, the ETH contributed by people will then be redeemable via a multi-sig wallet. There are currently 5 people on the multi-sig wallet, and it lists the members, and it continues on and says that the Assange DAO follows in the footsteps of the Constitution DAO, a movement that almost managed to secure an early, rare copy of the U.S. Constitution. It was bested in the auction by Citadel CEO Kenneth Griffin. After the failed auction, owners of its governance token were able to redeem their tokens for the original amount of ETH paid, but the token ended up trading at a much higher value on the secondary markets. Another DAO is looking to achieve a similar goal. It's known as the Free Ross DAO, which raised funds in an attempt to free Ross Ulbricht, the founder of the Silk Road online marketplace. It raised over $12.5 million in ETH at the time to bid on a collection of Ulbricht's artwork as a single NFT. The DAO won the auction and bought the NFT for over $6 million in ETH at the time. So I think that this is pretty interesting how these DAOs are going about trying to raise funds and essentially crowdfund money for the purpose of either freeing Julian Assange or freeing Ross Ulbricht. So you have a NFT that's essentially created by the person who the funds are being raised for, whether it's Ulbricht or Assange. They are the co-creator of these NFTs, and then the DAO comes along and then bids on these NFTs, and then the DAO holds the funds on behalf of or for the use of the person that made the NFT and who the DAO was ultimately created for, whether it be Assange or Ulbricht or something like that. So, I mean, it's really interesting. I to date, I haven't seen any sort of legal situation or governmental entity try to give a proverbial spanking to this sort of organization and clamp down on them for operating, I guess, out of the bounds of traditional crowdfunding laws. But this is just such a new phenomenon. I mean, we're at the literal bleeding edge of this intersection of decentralized blockchain technology with DAOs and how they're currently being used to crowdfund for certain purposes that, I mean, the government is clearly lagging behind on this issue. I feel like it's just a matter of time before they clamp down and then use one of these instances as a test case in order to try to exert their power over these sorts of crowdfunding situations and establish some sort of guidelines. But I just think it's really interesting that, the internet and the blockchain has, created a situation where you can crowdfund like this. I mean, think about it. This thing was set up. This is what the Assange DAO. This thing was set up on Thursday. That was yesterday, and it already raised over $4 million. It's insane. I mean, it just speaks to the power of the blockchain and the open internet. It's amazing. But I think that this issue is ripe for, some sort of, governmental interference, if you will. Ultimately, I think at some point, some sort of governmental agency is going to get, their feelings hurt and say, oh, you actually fall within my jurisdiction. I'm going to try to clamp down on you and make an example of you, and then come after one of these DAOs, engaging in this sort of crowdfunding. But we'll see how it all plays out. Next up, we could see that the Boston Fed, the Federal Reserve, and MIT publish open source central bank digital currency software. The white paper that they publish caps off nearly 2 years of research. They say the Federal Reserve Bank of Boston and MIT's Digital Currency Initiative published open source research software to support a, quote, theoretical central bank digital currency on Thursday. The Boston Fed and MIT have been jointly researching CBDCs for nearly 2 years after Federal Reserve Governor Lael Brainerd, who was recently nominated to be the Fed's vice chair, announced the Boston branch of the U.S. Central Bank was investigating blockchain and a digital dollar. Thursday's publication brings the central bank one step closer to a technical framework that could support a U.S. CBDC. Thursday's publication, which includes Open CBDC, a research paper, explains that the Boston Fed was able to develop a core processing engine for a general-purpose CBDC that could support nearly 2 million transactions per second with high-speed settlement finality. According to the white paper, developing Open CBDC was only the first phase of the project. Phase 2 will test the different designs and features not included in Phase 1, as well as access what, if any, trade-offs there might be with different sets of features. Privacy and interoperability are two of the issues to be analyzed in Phase 2. The Fed also said it would want an explicit law from Congress authorizing it to issue a CBDC before it considers adopting or creating one as well. And I think that this last point is a big part of the rub here. I remember I was watching Lael Brainerd's confirmation hearing before Congress, and this is one of the things that they actually questioned her on. And she pretty much, played past the ball with this response right here. She was asked whether or not the Fed was going to or had any plans to issue a central bank digital currency and whether or not she actually supported that. And she pretty much kind of skirted around the issue, but then stated that if the Fed were to do that, it would first have to, come in the form of Congress authorizing it via law or statute. That would be a prerequisite to the Fed issuing or instituting a CBDC, which, I guess at this point it's all up to Congress. I feel like they have two potential paths at this point. They can either, go the way of regulated stablecoins, where they're going to turn these stablecoin issuers like Circle into de facto banks and have them issue stablecoins that will be monitored and regulated by the government, or go the route of this central bank digital currency. I think at this point, in my opinion, they're probably leaning more towards the stablecoin route, with these stablecoin issuers being regulated as de facto banks. I think that that's just mainly largely in part to the amount of lobbying that is being, that is currently happening in Congress. If you recall, I think Sam Bankman-Fried was, the largest donor to the Biden campaign. He donated something like $500 million. It's insane. But there's also a lot of other big lobbying going on from these major players in the crypto game, all jockeying for position in order to shore up their scene in the space. If you want to check out the paper right here, the publication, here's a copy of it. It's pretty long, pretty in-depth, lots of technicals in here, but it's going to be linked down in the description. And finally, we can see here, I just want to go over the docket in the IRS staking rewards lawsuit, Jarrett versus the United States. As we can see here, the most recent docket entry occurred on February 3rd of 2022, and it was a notice of letters filed by the plaintiffs in this case, and we can see here's a copy of the docket, or the document that was filed. And it says it's a notice of letters. It says that there was a case management conference scheduled for February 10th. The plaintiffs wanted to update the court that about the most recent developments, and they submitted 2 exhibits to this filing. Exhibit A is a letter from defendants' counsel stating that the IRS has been authorized to provide plaintiffs a refund, and Exhibit B is a letter from plaintiffs' counsel rejecting defendants' offer. And the plaintiffs look forward to discussing these matters on the 10th. So we could see here is pretty much the settlement offer from the defendant, the government, the IRS. And it says, this refers to the above entitled action in which the plaintiffs seek a refund of federal income taxes for the 2019 tax year. We write to inform you that a full refund of $3,793 plus statutory interest sought in the complaint for the 2019 tax year has been approved on behalf of the Attorney General. Accordingly, the IRS has been authorized and directed to schedule an overpayment of $3,793. Okay, so they offered to settle. And here is the response telling them to go pound sand. This is from the plaintiff's attorney rejecting the offer. It says, thank you for forwarding the letter about the disputed tax. It says thank you as well for emailing the draft stipulation of dismissal. So you can see that the government clearly wanted to dismiss this case because I think they're caught between a rock and a hard place. The draft stipulation suggests that the Department of Justice's view that the proffered refund brings the parties' dispute to an end. Particularly after our recent call, we cannot share that view. During the call, you were unable or unwilling to explain the reasons for the department's proffer, or its meaning for the Jarretts in subsequent tax years, or indeed in 2019 itself. The IRS will also apparently not provide any assurances with respect to the sole issue that gave rise to this litigation, whether tokens created through staking a particular cryptocurrency constitute taxable income at the time of their creation. As the question will arise for the Jarretts again in subsequent tax years, they would remain at risk even if they accepted the proffered refund. Notably, you stated on the call that the IRS has not yet processed any refunds for the Jarretts. Therefore, the Jarretts reject the proffered offer and intend to continue vindicating their rights in court. We're happy to discuss the next steps at your convenience. So, I mean, they're pretty much telling them to go pound sand, and I think that this is great. I think that it really hits at the core of the issue. Rather than just kind of, it's not about the refund, as we can clearly see. I mean, it's about clarifying the rules and the regulations with regards to crypto staking. And I can't commend these plaintiffs enough for, having the fortitude to tell the government to go pound sand and taking this all the way down. So just wanted to give you guys this update. If you want to check this out, all of these links are going to be in the description below. As always, thank you for watching this video. If you enjoyed our content, please hit the like button. Please also subscribe to our channel. We'd really appreciate that. You can follow us on Twitter. Our handle is @CryptoBitLaw. And with that said, thanks again for watching, and we will see you guys in the next one.